Hi, I'm attorney John Mangan, and in my 15 years or so of practicing law in the area of trusts and estates, we often work with clients that have a lot of their wealth tied up in tax-qualified accounts. These accounts are things like 401ks, 403bs, and IRAs, and they might be traditional type or they could be Roth type. So the conversation that we typically have is, okay, someday when you pass on, where would you want this money to go? And how would you want your beneficiaries to receive it? In a lot of cases, it works quite well to simply name individual beneficiaries on the beneficiary designation form with the custodian for your account. For example, you might name your spouse as your primary beneficiary and maybe your children as contingent beneficiaries in equal shares. And that can work great in some cases. With that being said, there are also a lot of situations where outright distribution of tax-qualified accounts like these to our beneficiaries can be a recipe for disaster. For example, if you have children that are under the age of 18, and if you name them individually on this designation form, and God forbid you were to pass away before they turn 18, then they will receive their share, but probably not in the way that you envisioned. What would happen is we would, assuming that the amount of assets in the account exceed $15,000, we would have to open up a guardianship for that child. And then upon reaching the age of 18, they're going to receive everything in that account. They'll have full control over it, and they can take it out as soon as they choose. That might not be the outcome that you want. Another example of a situation that can be problematic is if you have an adult child and you want to ensure asset protection for them. Maybe you're concerned about things like going through a bad divorce, a creditor claim, a lawsuit, or a judgment. If you name them individually on the beneficiary designation form, there's a good chance that they're not going to have much, if any, protection over this type of account. Alternatively, we can create something known as a standalone retirement trust. And this is a great solution when we don't want to name beneficiaries individually. Here's how the standalone retirement trust works. You name somebody that you trust, that you have a high level of confidence in, as your trustee. And ideally, you name one or two backup trustees just in case your first choice is not able to serve. Now, someday when you pass on, if your standalone retirement trust has been named as the beneficiary of your tax qualified account, now it's the trustee of that retirement trust that's going to make decisions on how often and in what amounts your beneficiaries receive the inheritance coming out of this trust. And obviously this can be customized to your wishes. So you can either leave it fully in the hands of the trustee to use their discretion, or you might have some hard requirements about certain amounts or certain percentages going out of the trust at certain periods of time. The point is that this is very customizable, and it's a great solution if you're seeking to provide asset protection to your beneficiaries, or if you have concerns about their judgment and their ability to make sound decisions when it comes to their money. If you have any questions about a standalone retirement trust, if you want to find out whether this might be a good fit for you, or you just have some additional thoughts or concerns but want to learn more, please feel free to reach out to us. You can either give us a call or use one of the contact forms on our website. We're here to help, and we look forward to hearing from you.